I'm Dr. Jeff Kieliszewski, forensic psychologist. Welcome to my YouTube channel. I'm sure many of you have heard about the case of the Oxford High School shooting. This occurred in Michigan in November 2021 when a student named Ethan Crumbley, a 15-year-old, took a handgun from his backpack and he killed 4 other students and injured 7. So Crumbley has pleaded guilty to 4 counts of first-degree murder. Recently, there was a hearing to address the prosecutor asking for a sentence of mandatory life without parole. This is often referred to as a Miller hearing when prosecutors are attempting this sentence of life without the possibility of parole with a juvenile. The judge in this case will be announcing his ruling here in a few days, September 29th, 3 days from now. And then that'll be followed by the formal sentencing hearing on December 8th. So today I'm going to spend some time talking about Miller hearings. What are they? I'll be able to also offer some personal commentary on my involvement in Miller hearings. So in the 1990s, there were some high-profile cases, criminal cases against juveniles committing heinous crimes. These received a lot of media attention. And as a result, several state legislatures enacted laws that made it much easier to charge juveniles in adult court, and also sort of imposed more harsh sentencing for juveniles. At the time, then, we saw a dramatic increase in juveniles who were sentenced to mandatory life without parole. Frequently, these juveniles were sentenced when they actually weren't directly involved in the carrying out of a murder, but involved in a crime where a murder occurred. This usually took the form of more than one individual participating in a robbery, and then the victim was killed. In 2012, the Supreme Court ruled in a case called Miller v. Alabama that sentencing a juvenile to mandatory life without the possibility of parole violated the 8th Amendment's prohibition against cruel and unusual punishment. The majority opinion argued that the court must take into consideration several factors pertaining to a juvenile defendant in order to make this type of sentence. Some of the factors were the youth's chronological age at the crime, immaturity, family and home circumstances, other things. Now, this does not mean that a court cannot impose a mandatory life without parole sentence on a juvenile defendant, but the court must take into account, usually through evidence or testimony, mitigating factors or things they need to consider when making a sentence. And that this occurs in a special hearing called a Miller hearing. So the effect of this Supreme Court decision was that thousands of offenders throughout the country that were sentenced to mandatory life without the possibility of parole had to be resentenced. Here in Michigan, I think we had over 350 defendants that had to be resentenced. So, as part of the resentence, those individuals typically have to participate in a forensic psychological evaluation, and I've done several of those. Now, in these types of evaluations, the forensic psychologist has to address several factors for the court to consider based on and consistent with the Miller v. Alabama case. So, what are these factors? Well, I can go over the factors because I pulled an old report. The first factor that the court needs to consider, and I'll just sort of paraphrase or read this, is the character and the record of the individual offender and circumstances of the offense. When examining the character of an individual in this type of circumstance, providing information in regards to the character at the time of the offense and the current character is important. So, when you look at the personality, was the person exhibiting, for example, antisocial personality characteristics at the time of the offense? Was the defendant exhibiting sort of passive personality characteristics, were easily influenced by his peers or his friends in committing the crime? And then what you need to look at is personality now. So is this individual still exhibiting, for example, antisocial personality characteristics? Or are they a very different individual than they were when they first came in on their sentence as a teenager? Second factor in the Miller case pertains to the chronological age and what they call immaturity, I always say this one wrong, impetuosity, and failure to appreciate the risks and consequences of the behavior. Now, impetuosity is this idea of acting without thinking, which occurs with teenagers, but how much of that was a factor in the crime? And how do these factors play out in a person who's 17 years, 11 months old versus someone who's 14 years, 1 month old? Third factor you look at in a forensic evaluation for a Miller hearing, the offender's family and home environment. Was there neglect and abuse? Were the parents involved? Were the parents hardworking, stable people? Fourth factor, the circumstances of the offense, including the extent of participation in the criminal conduct. Did the juvenile, was he or she the one who pulled the trigger? Was this juvenile, did they only drive away the getaway car? I've had a couple of cases like that. The 16-year-old drives a getaway car but wasn't even in the store when the store was robbed and the clerk was killed. The brutality of the murder, the court will often look at that. And another factor they often look at is, was this murder premeditated or was it sort of an in-the-moment occurrence? A fifth factor that's cited in the Miller case that the court needs to examine, the effect of the offender's youth on the criminal justice process and their ability to comprehend a plea agreement. So, thinking about the defendant's age at the time of the case, were they able to participate effectively in assisting their defense? Were they offered a plea deal? And if they were, why didn't they take it? That's a question I'll directly ask them. And the sixth factor that's cited in the Miller case that the court needs to consider is the individual's possibility of rehabilitation. So, what have they done in prison to better themselves? Education, have they been involved in programs? Have they successfully completed programs in prison? And because of these rehabilitation efforts, are they different now than when they were sentenced as a juvenile? Now, oftentimes when I do an evaluation in these cases and I have to testify, the offender has already served several years. A lot of these cases are from the 90s, and many of these guys are already in their 40s. Now, in these cases, the judge typically has three choices for a new sentence. The first one is keep the mandatory life without parole in place. The second is a 25 to 40 year sentence. And the third is typically a 40 to 60 year sentence. Now, let's say you've served 28 years in prison, you have your Miller hearing, and you're resentenced to a 25 to 40 year sentence. Now, that doesn't mean you just walk out the door. What that means is that you are now eligible for parole. You have to go through the same process to apply and go through a parole hearing, and you can be denied parole. So like I said, I've done several of these. In fact, I'm testifying one here in a couple days, Friday. It'll be very interesting to see how the judge rules in the Crumbley case, or how these factors are taken into consideration. In my experience doing these Miller hearings, I've had them turn out all types of ways, keeping the mandatory life without parole, or other sentences. So if you're interested in these topics, if you're interested in forensic psychology, subscribe here. You can also find me on various social media outlets. I'm on Facebook, Instagram, Twitter, and TikTok. Everything is under Dr. Jeff Kieliszewski, forensic psychologist. Thanks.